the definitive guide to petitioning creditors' bonds. By law, creditors have the right to file a petition to force a delinquent debtor into bankruptcy when the debtor is reluctant to file a voluntary bankruptcy. Once a petition is filed, a court can declare the debtor bankrupt and appoint a trustee or receiver to assume control of the debtor's assets. The courts will then require a creditor to obtain a petitioning creditor's bond. What is a petitioning creditor's bond? This surety bond is used in certain bankruptcy proceedings, which is required by the court when a plaintiff is petitioning a defendant to be declared as officially bankrupt. It guarantees that the debtor will be compensated for any costs or fees they might suffer as the result of the seizure of their assets or properties, in case the court decides to deny the petition for bankruptcy. In essence, it provides protection to the debtor against any damages or loss. Is collateral needed for this bond? Generally speaking, fiduciary bonds, probate bonds, don't require collateral, but rather we are basing the decision primarily on these four factors: credit score, financial capacity of the fiduciary, experience, and character. How much does a petitioning creditor's bond cost? Like in all bonds, sureties or underwriters that write bonds for petitioning creditors in bankruptcy must conduct a thorough background investigation of the applicants, particularly focusing on the creditor's financial strength. An applicant with a good credit background and significant net worth relative to the bond penalty is assured to be issued this type of bond without reservations. Here is an example of this bond in action. Carl owes a large amount of money to Derek. However, even after repeated requests by Derek, Carl refuses to pay his debt, saying he has no money because he was laid off from work. But Derek knows Carl's house is fully paid for, and its value is enough to cover the amount owed to him. Derek decides to petition the court to declare Carl legally bankrupt and to appoint a trustee to take control of his house. Before filing his petition, Derek must first obtain a bond for petitioning creditors in bankruptcy, aka petitioning creditor's bond, to protect the rights of Carl while litigation is ongoing. Carl can seek indemnification from the bond in case he sustains any damages or loss if the court decides he is not bankrupt or if Derek withdraws the petition. Surety Bond Authority offers a simplified solution and competitive rates for all your bonding requirements. You can also request a free consultation. Call us at 800-333-7800 or visit our website at www.suretybondauthority.com and get your free quote today.